to start right away.
This meeting
my
is
name
being
is
recorded.
Shola Dosumu. I'm the chair of the Corporate and Regulatory Council Committee of the Nigerian Bar Association section on business law. I'll use the acronym CRCC to describe this committee going forward. The CRCC was established in December 2018 and is one of the foremost and focal committees of the NBA-SBL. Our mission is to promote professional and business interests of in-house counsel who work for corporations, associations, professional and business interests of in-house counsel and other organizations. And how do we do this? Through information sharing, education, networking, and advocacy. So this webinar is one of the things we do to promote our activities. The committee provides a platform for the corporate counsel to enhance proficiency in the practice of corporate and commercial law in Nigeria, amongst other objectives. So the team is myself as the chair. We have on the call as well, Mrs. Anastasia Breimer, who was head of legal and legal advisor at the Securities and Exchange Commission. She sits as the first vice chair. We also have Sheson Shobowale, who is currently head of legal of Union Bank of Nigeria. He's the second vice chair. And last but not least, we have Mrs. Bukola Daniel Durotinwa. She sits as the secretary of the committee and is a legal manager at Total Energies. So the CRCC is thrilled to be hosting the second Business Law Weekly series, and we shall be discussing do's and don'ts when a corruption issue arises in your organization. We have a brilliant set of speakers here with us today. And like all of you, I am eagerly looking forward to what promises to be an informative and educating session. Please remember that the Nigerian Bar Association section of business law is social. So please check us out, check up all of our activities on Facebook, Instagram, LinkedIn, Twitter, and of course on our website, www.nbasbl.org. You can find how you can join any of the committees, and we're more than happy to welcome you. Also, please note this webinar counts towards your continuing professional development, your CPD points. So a link is going to be provided in the Q&A box. Just register, click on the link and register and claim your points. And also please remember, once the session starts, to send in all your questions into the Q&A box, and our speakers will try to do justice to your questions. But before I introduce our speakers, and this is a prompt to Ayomikun to please share the speaker presentation in a minute, I would like to recognize and welcome the section of business law chair, Dr. Adeoye Adefulu, and other council members who are present at this webinar. I know Doctor is shy, so he's not going to put on his video, but you're welcome. Thanks for joining us. Now, let me introduce our speakers. Ayomikun, I don't know if you can share our speaker slides so that the audience can also follow through. Thank you. Whilst that's coming up, I will thank you very much. So if you go to this third slide and put that on presentation mode. Great. Okay, so I don't see what you'll see, but okay, fantastic. Thank you. If you can put that on presentation mode, please. Speaker mode. So we have Titilayo Okoye, who's the Chief Compliance Officer at Savannah Energy Group PLC. Savannah is a UK-listed company focusing on delivering energy projects that matter in Africa. She's responsible for driving compliance, ethics, and enterprise risk management within the organization. Prior to joining Savannah, Titilayo held the position of country head, ethics, and compliance at GlaxoSmithKline Pharmaceuticals Nigeria Limited. Titilayo has over 15 years experience in a variety of senior compliance and legal roles, within FTSE 10 multinational companies, including British American Tobacco Nigeria, Guinness Diageo Nigeria PLC. Titi started her legal career at Denton AC&S Law, one of the leading law firms in Nigeria, where she has advised both multinational and domestic organizations on compliance, commercial issues, corporate governance, intellectual property, and labor law. You're welcome, Titi Layo.
Thank you, Shola. Thank you.
We also have Oluchi Aniaka. Oluchi is the area head of compliance for British American Tobacco, West and Central Africa. This is a multinational FMCG company with footprints across the globe. She drives initiatives and programs aimed at transforming and embedding compliance in the business to ensure delivery of business results with integrity. She also previously managed anti-illicit trade agenda for BAT across the Western Africa Central area, as well as the company's litigation portfolio in Nigeria. Oluchi is a business lawyer with over 15 years experience. She has advised large and medium-scale businesses on different aspects of Nigerian law, including capital market, energy, project finance, corporate restructuring, corporate finance. Oluchi is driven by passion and ethics in both her professional and personal life. Oluchi, you're welcome.
Thank you very much, Shola. Hi, everyone.
Now, we have Olutomi Ojo. Tomi is a versatile professional with competencies and experience cutting across compliance, company secretarial services, legal and banking practice, corporate governance, risk management, internal control, and human capital management. She's a fellow elect of the Chartered Institute of Bankers, Nigeria. She's currently the Chief Compliance Officer at Heritage Bank PLC, where she spearheads the drive for automation of various compliance functions. Tomi has at various times served as company secretary and legal advisor to the board of many institutions. She's currently a member of the Association of Chief Compliance Officers of Banks in Nigeria. Welcome, Tomi.
Thank you very much. Hello, everyone.
And not last but not the least, we have Amelia Madubike. Amelia is currently the Deputy General Manager, Compliance, Integrity and Ethics at Total Energies EP Nigeria Limited. Prior to this position, she worked as a manager, compliance support and methods, and as an auditor working both in Nigeria and at Total Energies headquarters in France. She's interested in research and she loves to dance. Welcome, Amelia.
Thank you very much, Sola. Hello, everyone.
Okay, thank you. We've gone past 10 minutes. I'm just going to give our speakers 5 minutes each to talk to our topic, do's and don'ts, when a corruption issue arises in your organization. So I'll start with Titi. So what should you do when a corruption issue arises in your organization? Thank you.
Okay, thank you very much, Shola. So I'll start by, first of all, explaining what corruption is. I'm sure a lot of us know, but just for purposes of this meeting. Corruption is very broadly used, and in most organizations, it includes bribery and kickbacks, facilitation payments, fraud, conflict of interest, falsification of records, insider trading, insider information, excessive gifting and entertainment, nepotism, favoritism, cronyism, embezzlement, and the list goes on. Really, the job of a CCO really is to manage, to be proactive, and of course, if anything happens, to be reactive. But the question really speaks to reactive. So the success and effective management of any issue really starts from the moment you receive the report in terms of what you do with it. Information is very key. So the first step is ensuring that you gather adequate information relating to the issue. And I say that bearing in mind that sometimes, these reports comes through a particular source, and some, and there are various sources. For it could be whistleblowing, it could be audit, monitoring, and even investigation. as much as possible, try and gather as much information as you can. Bearing in mind that there may be certain instances in the case of an anonymous whistleblower where you may not have enough information, but for all intents and purposes, let's assume that we're able to gather the information that we require. Adequate information is very key. It's key in basically identifying and mapping out your stakeholders. And in any investigation, the likely stakeholders are, okay, the source, who is the reporter. You have the subjects. The subject is the alleged culprit and other people who may be, related to that incident. You have HR, you have legal, you have security, the security and investigations team, audit team, the management team. For those of us who have some organizations that have maybe PLC reporting responsibilities, obligations, the board of the PLC, and then in certain instances as well, the regulators. That is where the alleged breach or the nature of the corruption is that which must be disclosed to a regulator. And in terms of, obviously, as you don't just rush into the investigation, there are steps. The stakeholders, after identifying the stakeholders must be briefed. At this point, because the subject has already been mapped out as part of your stakeholders, you have to take out the subject from the list of, or exclude the subject from the people who will be briefed. And this is to preserve the integrity of the investigative process, because you don't want to start passing on information. There's certain information that you need to gather, or there's certain steps that you need to gather before you make contact with this with the subject. It's also important that you prepare, after identifying these people and briefing them. The next step is to prepare an investigation plan and share with stakeholders for alignment. The investigation plan would contain details, and these details include the people who will be part of the investigation process, the processes itself, in terms of, and processes could be maybe the systems, for if it's financial, the ERP systems, bookkeeping systems, or anything of the sort that you have. And then of course the procedure in terms of what is written down. It's important that all of this is taken together and put together into a plan, and it will ensure that completeness as well as quality of the process. And the next step, really, once this is done, you need to get alignment of your stakeholders and input from your stakeholders, because, and it's important to get alignment, because there are other things, as a compliance officer, there are different elements that do not necessarily lie within your control, but just to ensure that there's proper resource identification and resource allocation, it's good to get alignment. And of course, carry out the investigations in line with the plan. The outcome will either be to confirm or to rebut the allegation. If they're at this point, if there are regulatory requirements, I know that, in my previous, or one of my previous employments, it was a regulatory requirement that you inform the Special Fraud Office, for example, in the UK, when there are allegations and the outcome of such allegations. So at the point where it is substantiated or otherwise, you need to inform them. And then that then leads into the next phase, which is a disciplinary process. And the disciplinary process includes the consequence management phase.
Okay.
Where it is, and as an investigator, obviously, again, the role of I keep saying, the role of compliance is to be proactive, as in preventive, and then there's also the reactive bit. But again, I know that this is more what you do, reactive, but you should also bear in mind, you should not lose the proactive mechanisms as well. So in the course of the investigation, in the course of gathering information, there will be certain things will come to light, and which will present process improvement opportunities. It's very important that those process improvement opportunities are also highlighted and brought to bear in the course of the investigation by way of recommendations and process improvements.
Okay.
And this will be presented to the management or to the board. Sorry, I beg your pardon.
Can I say you hold that thought for a second?
Okay.
I'm going to revisit that in a second. I just want Oluchi to have a chance as well to answer that same question. So Oluchi, how will you do, what will you do when an issue of corruption arises in your organization?
Okay, thanks, Shola. I think that when Titi was speaking about, what constitutes corruption and the processes, I was actually blown, because I was just thinking how very similar what she has said mirrors what we have here in BAT. Well, like has already been introduced, I work for British American Tobacco. It's a multinational, which means that we are present in both the UK, we're listed in both the UK and in the US. And by that fact, we have the UK Bribery Act and the Foreign Corrupt Practices Act applying to us. So while all the elements that, I won't repeat all that Titi has already said that goes into corruption, but I just want to make a particular point that regarding bribery, by virtue of that nexus we have to the UK Bribery Act and the Foreign Corrupt Practices Act, which apply to us here in Nigeria and indeed in West and Central Africa, because it's extraterritorial in nature. We look at bribery in an expanded scope. So for us, we see a bribe as any gifts, payments, benefits, whether it's hospitality, kickbacks, job or work placement, investment opportunities offered in return for a benefit, whether it's a personal benefit or work-related benefit. And for you to see how expansive it is, we don't even consider bribery as just when it has been paid or when it has been received. The mere fact that you have offered to pay or that you have agreed to accept, constitutes that whole thing about bribery. So that once we have the allegation that someone has been involved in bribery or any of the other forms of corruption, because here in BAT, we have zero tolerance to anything at all related to bribery and corruption. And for us, it is wholly unacceptable for anybody that is connected at all with BAT, whether it is employees, our third-party business partners, or our stakeholders, to be connected or linked in anything at all related to bribery and corruption. So the first thing is that once we get that, and it has to do with bribery and corruption, then all of our red flags are up. And this goes all the way to the group, because bribery is one of those very huge misconducts that goes all the way to the BAT PLC. And then you have the group head of compliance also interested in what we do. And as per our processes, if such an allegation comes, we have our what we call SOBC assurance procedure. SOBC stands for our standard of business conduct. In some other organizations, they might call it different things. But for us, it's referred to it as standard of business conduct. And it has the processes. So when we get these reports that someone has done something, the next thing is first is to give the mandate for investigation. And the reason we try to be methodical in the way we approach this is because we know that, at some point, maybe there might be a need for disclosure. You might have someone going to court, or you might just have some authorities coming to us and requiring us to provide documentation relating to certain allegations. So we are very methodical in our approach. And any investigation has to be thorough, professional, efficient, and carried out in a way as to constitute very minimal disruption to our business, and to also minimize typical investigation risk, like, breach of confidence, data privacy, and all of those principles. And then, but primarily, the intention is also to identify the root cause. So while we're trying to establish what has happened and then to remediate it, we're also trying to also establish what could be the root cause. Because, when you treat the symptoms without treating the underlying reason for something to have happened, then you would only have applied cosmetic solutions. So we identify the root cause so that we can nip it. So that's basically what we're going to do as far as SOBC assurance procedure is. We get the reports, and then we give the mandate for investigation. The investigation happens according to plan, and then we remediate and review our control processes, which may sometimes mean that we'll have to tighten controls, carry out awareness, or sometimes someone has to leave the business for very drastic cases. Thanks, Shola.
Fantastic. Thanks, Oluchi. Bang on the dot of 5 minutes. Thank you very much. All right. So, Tommy, same question goes to you as well. Do's and don'ts when a corruption issue arises in your organization. So, how do you handle this at Heritage Bank? Kindly unmute and let's hear you out.
Thank you very much, Shola. I'm tempted to just concur with the previous speakers, Titilayo and Oluchi, because there are various elements of what they've said that you also find here in Heritage Bank, or indeed the banking industry. Banking is an industry that is very much regulated, highly regulated. So you find that you must ensure adherence to lay down procedures to ensure that, if there is an issue, and I always personally say, with every investigation, it's useful if you start off on the premise that the matter might end up in court. Because if you do that, that helps you to streamline your thought process and ensure that you adhere to every element of, your policy, as well as regulation and laws where applicable, to ensure that you do not flout intentionally or unintentionally any of those. So essentially what we do is similar, as I said, to what Titilayo and Oluchi said. There are various sources of corruption allegations or issues, because again, you have, there's a bit of a difference between the two. Occasionally you have an allegation which is not established, but occasionally you also have a situation where an issue has occurred regarding a staff in the past, and that is just brought to light. So the way you would handle the two are, somewhat similar, but there are a few differences. Now, the assumption, and I'd like to take from Titilayo's standpoint when she spoke about being proactive in this instance, is that there must have been certain documentation as well as practices that precede such issues, because these issues will arise from time to time in whatever form. So it's expected that you have your staff handbook. It's expected that you have various policies that guide how that define, first of all, what offenses are, what is permissible and what is not, and also defines what process is to be followed in the event there's a corruption allegation or an issue arising. Those policies, I assume, would usually be publicized in the organization so that everybody is aware of what the requirements or what the provisions are. And subsequently, when an issue arises which needs to investigation, first of all, there must be clearly defined persons and, as has been said before, stakeholders who are charged with the duty of properly investigating. There may be times, just as one of the previous speakers alluded, that you may, for the sanctity of the investigation, need to ask the person who's suspected of an offense, to step aside, whether by way of suspension or, redeployment to another role. But in those cases, you also still need to be mindful of the provisions of the law, because we have had instances, for instance, where you have staff coming, charging the bank to court, or, instituting an action based on the fact that you have suspended them for X period of time, which is longer than, probably what is stated in the policy or what is permissible, under law. So it's important that one is guided when taking such processes. The other thing I'd like to quickly comment on is the need for reporting. Depending on the person who is a suspect, it's important that you carry along the person's supervisor, or if it happens to be a director, it's important that the board is formally or informally briefed of the fact that an issue has arisen, which you will go through the normal steps to investigate. I say this especially because, as I mentioned before, banking is a highly regulated one, and the chief compliance officer, just to protect the sanctity and the integrity of that office, reports to the board of directors. So it is important that where there are issues that may affect whether the brand or the operations of the institution or organization, that they are brought to the attention of the board. The other thing I should also mention is that the investigation must be thorough. It must go through a process whereby the suspected offender has the opportunity to prefer an explanation and answer questions on the allegation. This for us is important so that there's no doubt as to the fact there has been clarity in requesting for information and obtaining that information. Furthermore, it goes also to fair hearing, that the suspected offender has had the opportunity to defend himself and provide documentation where appropriate. I should also mention that the compliance officer or whoever is investigating must be an objective person. You don't go into an investigation believing that this person is definitely guilty. Oh my goodness, there's so much evidence that has been tendered against this person, he's definitely guilty. So you must have an open mind going into an investigation so that you are able to extricate facts, and match them appropriately with your policy or regulations to ensure that there is indeed an offense for consideration as mentioned by the person who reported.
Thank you, Tommy. Thank you very much. It was very interesting when you mentioned that sometimes the allegation of corruption may be against the directors. In fact, we have very interesting questions. And one of them is that what if this allegation of corruption is against you as the chief compliance officer? So hold your thoughts, all of you, whilst I go on to Amelia before we get into the Q&A. So Amelia, do's and don'ts when a corruption issue arises in the organization. How will you handle this, either in Total or in an oil and gas or energy company? Can you unmute yourself? Thank you. You have 5 minutes.
Thank you very much, Shola, and good day, everyone. And I want to say a big thank you for this opportunity to discuss such a topical subject. I want to just start by saying that I would liken corruption to a pandemic. And like all pandemics, it's global, it's a global problem. So it covers companies, countries, and indeed business sectors and individuals. And every day, the stakes are getting higher as international companies are sometimes bound by both the conventions that they sign into, as well as the local laws of the countries of operation. And it's clear that some sectors are more prone to corruption than the others. And for instance, recent statistics show that oil and gas industry, pharmaceutical industries, and some other industries. In fact, the oil and gas industry and the pharmaceutical industries rank highest, in terms of corruption settlements. So without repeating what the others have said, I actually agree. I just want to state that over time, in the past 30 years, the settlements, the FCA settlements on FCPA settlements on corruption had grown tremendously. It had been around $3.6 billion over the last 30 years up to 2010. But between 2010, 2011 and 2022, it has jumped to about 21 billion in settlements for FCPA violations. So what I'm trying to describe is that the stakes are high. Companies need to be very aware and take actions about this. And just to digress a bit, I would talk briefly on how to prevent, because I believe that we prevent, we detect, then we respond. The topic of today is how we respond. To be able to prevent, I think the first step is to have a clear risk assessment, corruption risk assessment done by companies. This is how we approach it in my company, in Total Energies. We perform a corruption risk assessment to determine or identify the core risk areas for the company's business. I mean, those areas that could affect negatively the company's business model. And when these are identified, you document in form of a code of conduct. One of the speakers alluded to such. In this code of conduct, you clearly define the culture of the company, the rules of engagement the company employees must, adhere to prevent any cases of corruption. And when you have this documented in a code of conduct, it is communicated. In my company, the standard, in fact, is a policy of zero tolerance. Somebody mentioned that as well, to corruption of any form, active or passive. Now, talking a little bit more again about how to detect. So when you have done a risk assessment, you put in place a proper compliance organization that would attend to such issues when they arise, for instance, or even first of all, begin to train your employees, train your third parties, create awareness, educate on all aspects of corruption and how they affect the business of the company. So when this is done, you now look at how to detect. For detection, I would say that in my company, we have a procedure on ethics and compliance investigation process. So such procedures are domiciled where all employees can access them and can reference them. And a way to detect that I want to really talk about is to have a whistleblowing mechanism. This is very important for companies, especially international companies, because the regulations would want to check, the regulators would want to check if you have those processes in place and if they are working. Now, when you establish such a procedure, it also helps to guide the employees on how these processes will be handled when instances like this occur. So to detect, you have these procedures, it's communicated, and then you have a whistleblowing mechanism. A key aspect of our company's whistleblowing mechanism is the fact that the whistleblower is protected. It is clearly documented that a whistleblower is protected from all forms of retaliation. This is a way to encourage people to come forward when they have cases to report. Now, when you have all this put in place and then corruption occurs, then you have to respond as a company because you've set the rules. And when you have a corruption incident reported, the first step to take, of course, is to review it and investigate. I want to state that if you don't ignore, as we talked about do's and don'ts, try not to ignore any case. Once a case is brought forward, ensure it is investigated. And how do you do this? When you have a dedicated compliance team, you could have, depending on the size of the company, mine is an international oil company, so it's large. So we have an investigation team that would look into these issues and then investigate. So the don'ts, don't ignore any alert, no matter how trivial it may sound. make sure it is investigated. And if you investigate and you don't find merit, document to show that action was taken, but there was no merit. But if you have reason to continue into a full-blown investigation, make sure a report is issued at the end of the investigation. One of the speakers talked about preparing yourself for litigation when you have a corruption case. This is real because most times these things end in litigation. But when you have a clear process documented, it's easier to defend the position of the company, for instance, when such litigations come forward. So as a way to summarize, don't waste time in an investigation, because sometimes this is also not very positive, message for the company, as well as the subject of the investigation. We have to also consider the emotional impact of an investigation. These are most times our colleagues, and in some instances, external third parties. Now, I want to make a very final point on third parties. We've seen in recent cases, in recent FCPA cases, that in fact, for 2022, all the corruption cases were hinged on third parties and intermediaries, all of them, every single one of them. I think this is a pointer, and I think that is something that companies need to pay attention to. It means that we need to probably digress our efforts a bit towards educating our third parties and intermediaries, because when actions are performed on our behalf or contracts are executed and corruption incidents occur, we could be held liable for such actions of our intermediaries. So we need to begin to sensitize a bit more, which we do today in my company, sensitize, draw attention to our third parties, explain and expect them to institute or put in place similar anti-bribery programs as ourselves. Maybe not necessarily at the same scale, but at least to show that they have put things in place to checkmate corruption. In fact, corruption is so inherent in businesses that no matter the amount of or the level of sophistication of any compliance program, it does not guarantee total avoidance, or it does not guarantee the company that corruption will not occur. But what is important is that you can show that you have done the right things, you have put the appropriate measures in place to deal with them when they occur. Thank you. Hello, I'm not sure if we're still here.
We are, but have we lost that model?
Okay. Okay, so I guess we can just go on.
Oh, don't go on. Thank you. I'm here.
Okay.
Thank you. Sorry about that. I think slight glitch with my internet interconnectivity. Thank you very much, Emilia. I think, and to the point you made, I'm just mindful of the audience as well. When you mentioned the FCA, that's the Foreign Corrupt Practices Act, just so that non-lawyers who may be on the webinar can clearly understand that. So thank you very much. Quickly again, everyone, if you haven't sent in questions, please do so in the Q&A box so that our very qualified speakers can answer them. And don't forget as well, there's a link in the Q&A box as well of the CPD. Those are your continuing professional development points. You can claim them by attending this webinar. I think you get 1 point for doing this. Don't forget that it's a requirement that all Nigerian lawyers, either in legal practice or in employment, like most of you, must comply with the Nigerian Bar Association's mandatory continuing legal education professional development program. So click on the link, claim your points. Thank you very much. So I'll quickly go into the questions, and I think there was one directed at Titilayo. And the question is from Timothy Folarimi. And the question is saying, what does Titilayo think about outsourcing internal investigations to law firms? So would you outsource it? These investigations, all of you have mentioned, when you're investigating corruption practices, would you do this yourselves? Compliance team, would you outsource it to law firms? Have you ever done that before? Can you just please answer that? Thank you, Titi.
Well, so basically, we would, yes, there are opportunities where we can outsource investigations to law firms, especially those investigations that are of very sensitive nature, and obviously for reasons relating to privilege, and because we want to maintain that privilege, yes, it will be handled from top to bottom, from the beginning to the end, by a legal counsel. I've done that in the past. I haven't had to do that in like recently, but yes, we have done that in the past. And that is not uncommon with international companies as well. Emilia talked about and I guess Oluchi talked about maintaining the integrity of the investigation process and ensuring that it's able to withstand scrutiny. So sometimes, yes, there is a level of expertise which lawyers would bring to play, and also because of the sensitive nature. So for those cases, yes, we will use external counsel to manage that. Actually, the law under the UK Bribery Act and DOJ, it does require that it is handled by external solicitors.
Thank you very much, Titi. So that should be very exciting for some in our audience who are lawyers in law firms. The opportunities for investigations on corruption issues. Thank you. Oluchi, what happens where the compliance officer is the alleged culprit of the corruption allegation? How do you handle this? This is from Oluwafikayo Obadofi. Very quickly, Oluchi.
Okay, I think that's a very good question. So this is going to be, you already know about a very key principle of law, which is that you cannot be a judge in your own case. So where a corruption allegation or any misconduct is alleged against the compliance person, I certainly won't be the one to manage the investigation or the processes. I would have to step aside. And then it has to go to my line manager, right? And the process is going to be just the same as if it is any other person in the business. Because for us, it does not matter who an allegation is brought against. It just means that where the superiority of the person involved, or as in the case of this question, where I manage the process and the allegation is against me, it simply means that I will not be involved in the investigation or any of the processes relating to the procedure, from investigation to the reporting to the remediation. I'm just going to be the subject matter, the person who gets interviewed, and have the process done on me. And I think that one key thing about, imagining that at some point you might be the person on the other side, when the shoe is on the other foot, is that it helps you ensure that even when you are the person, administering the process, you're being humane and you're actually being a human being. You're not, just going all hammer on the person because you know that the tables could turn, and you would want that same understanding, that same you would also want the same sort of treatment that you would have given to your other colleagues to also be meted out to you. And that's the way to test that your process is actually has a human face to it. But directly answering your question, if the allegation is brought against me, the process as we have it laid down is still going to happen. It's just that I'm not going to be the one at the helm of the affairs because I cannot be the judge and the jury in my own case.
Thank you very much, Oluchi. So my next question goes to Tomi. So Anita Ofodile wants to know what, in your opinion, is the most important attribute, both from a professional point of view and from a character perspective, that a compliance officer should have. So what's that special attribute that you should have? Tomi, okay.
There are several. I'll start with courage, because a compliance officer's role is one in which you occasionally have a number of undesirable roles to play. You have to investigate, you have to ask the hard questions. Therefore, you must have courage, sometimes in speaking to senior persons and persons that are even above, your own grade level, in order to extricate facts relating to a matter. You must also, I'm sorry, can you hear me?
Yes, yes.
Okay. A compliance officer must also be very knowledgeable of both laws and regulations, and you must also know the internal policies. It's possible for, offenses to be brought up, or mentioned, but you must first actually establish that there are offenses that are outlined in your own policies or indeed under regulation, just to ensure that you don't actually end up um, administering wrongful, for want of a better word, judgments. A compliance officer must also be very much aware of the processes, that that are prevalent in his organization. For instance, as a banker, I do not and cannot limit my knowledge base to just matters relating to compliance, but I must ensure that I actually have some good knowledge of operational issues, of legal issues, of every, essentially every department within the bank, because as a whole, we must ensure compliance, not just of one team, but of all teams and divisions within the bank with laid down laws and regulations. So I think those are some critical attributes that a compliance officer must have. Thank you.
Thank you. Thank you very much, Tommy. My next question goes to Amelia, and it's from Timothy Folarimi. So when it comes to information gathering during your investigation process, how do you manage the company's risk exposure? Because the information which is not subject to privilege gathered may have to be turned over to investigators or regulators. So I think this is talking about what confidentiality clauses or what confidentiality trigger will you bring if your regulator asks you to bring over documents to them? Are you going to hand over everything to them, or are you going to be able to claim privilege for certain documents? How has that worked in any of your investigation processes?
Okay, thank you very much, Shola, and thank you for that question. I think when it comes to investigation, just to point out, like to support the points made by Tommy, confidentiality is key. In terms of gathering information, you must respect the confidentiality level of the information you have gathered, not just to protect the company, but also to protect the employees, because these days we have regulations affecting or guiding the use of confidential information, personal data, and what have you. So as a company, so we talked about confidentiality. I'm going to talk briefly again about the integrity of the process. Now, you know that as a compliance officer, you are an investigation officer, your integrity is always your word. So if you have informed the subject that you're handling the investigation in a confidential manner, you have to continue to maintain the caveat that it's up to the extent that is required by the law. In which case that if you have need or a requirement to provide information in a process, in a legal process, you may have to oblige to the extent that you have the information available to you. So when it comes to guarding confidential information, it is important, it is key. You respect the rules, you respect the terms of engagement with the subject, as well as the requirements of your company and the regulations and the conventions that have been signed on to. Now, speaking specifically about how we deal with responding to regulators when they ask for information, I think the key word is to cooperate. Cooperation in most instances makes it easier for the company to defend itself, even for the employees to defend themselves. We have to cooperate with the regulators. We have to, as much as possible, be very transparent And accountability is key too, to show that the company is taking responsibility for whatever actions have been taken. Sometimes this could be the distinguishing factor between two companies if they have both engaged in similar offenses. The approach, the openness, the cooperation level, the accountability, and the actions that the company has taken are all ways to show that the company is not in support of the corruption incident that has occurred. And at the same time, the company is taking action and has processes in place to protect the actors. So I'll stop here, but I want to stress that point that confidentiality is key, and we have to respect that to the extent required by the law. Thank you.
Thank you very much. Fantastic answers from our speakers. So some of the other questions I see here: can a company be sanctioned for an infraction committed by the employee of the company? I think that's quite simple. Yes, in certain instances, especially where the act is done by those who bind the company, very senior managers, directors, certain laws or certain instances, yes, certain of those laws would imply that the company may be fined, or that director may even go to jail for such infraction. Another question is, hello, what companies do the FCPA apply to? So the FCCPA, which is the Foreign Corrupt Practices Act, which I mentioned. So I think the simple answer to that is US listed companies, US nationals, anyone who owns the US green card, and those who are US issuers of securities. So for example, if any of your companies have bought shares in any UK listed company, the FCCPA would definitely apply to you there. I'm just going to, so basically I'm seeing a lot of questions around how do people react to all of you in your workplace, because you are looked at like the policemen or policewomen of the organization. So people don't chit chat with you. Or do you have less friends in your organization because of the unique jobs that you do? So anyone can answer that. More friends, less friends?
Well, that's an excellent question. In fact, once I had to describe my job function to my son, and immediately he said, "Oh, so you're a police officer," you know. Well, you have to strike a balance, because you must be approachable to the extent that people can give you information where need be. And in fact, just to speak to the whistleblowing issue that I think Emilia mentioned earlier, the chief compliance officer is usually one of the anonymous recipients of information coming through a whistleblowing source. So it's important that you are approachable, but you must not allow approachability affect your integrity and your professionalism in doing your work. The chief compliance officer is almost akin to an independent arbiter, as it were, in looking at various issues that arise and handling things. So I'll just stop there in the interest of time. Thank you.
Thank you very much. In one very quick minute, I'll just go around our speakers. Titi, do you have any tips for compliance officers or aspiring compliance officers? Do you have any tips for them?
I just want to borrow from what Tommy said before, that it's very important to have the knowledge of the business, and to move away from that stereotype that you're a police officer. You also need to embed yourself within the business. Let them see you as a business partner. I like to say that compliance really, it's like allows you to run properly. It shouldn't be seen as a blocker, but it's really like brakes in a vehicle. The brakes in the vehicle are not put there to stop you, but it allows you go faster, right? So it's very important as a compliance officer to position yourself that way. And, that way you build trust and, openness, and people communicate with you better. So that if there's any takeout from this session, that is it. Compliance should embed itself as a business partner, and that would guarantee having a seat at the table.
Fantastic. Thank you very much. Oluchi, please, how would you approach a situation when you notice an infraction and but you've raised it, or there's a whistleblower allegation against an employee, but your management have asked you to turn a blind eye or look away. In 1 quick minute, how will you deal with that?
Okay, well, I think that uh, that's really a hypothetical question because for BAT, that situation does not arise. And that's because we have a commitment from our CEO up there in the Globe House, noting that no wrongdoing, no speak-up concerns that have been raised will not be addressed. So matter of, sweeping something under the carpet, maybe because of the person involved or because of how sensitive it is or because we're concerned of how that's going to be viewed. And so we want to sweep it under the carpet. That situation, in my experience, and I've been doing this for almost 7 years now, in my experience, that situation has not arisen. But in the event that a whistleblower or a speak up has been raised and has been brought to knowledge, and I have, as per the process, try to do what is expected to be done, and then it's been shut down. Now, just to ensure again that that process, we maintain the integrity of that process, it may require that I go upstairs, just go upstairs to inform, like if it is within the area, I would need to go upstairs to higher management to raise this. Because, and the reason why this is important is when someone has raised a concern, right, to the business, and this is not handled, the person feels that, okay, if the business is not going to handle this, I'll go to the press or I'll go to the regulators. So now you're actually forcing the person to escalate the concern. Whereas it's something that you can investigate internally. And then if it's something that is still ongoing, you nip it immediately, you address it, and then you provide feedback to the person that has raised the concern. Where this is ignored, then you are simply asking that person to look for alternative channels to ensure that their concerns are addressed. And that may not reflect well on the company because the question is going to be, was this raised to the business? Yes. What was done about it? Nothing. We've seen instances where this has happened and the repercussion is not beautiful.
Yeah.
So that's what's going to happen.
Yeah. And if I may just add, in these days of criminal and civil liability, I mean, companies and management of companies must be seen to be taking reasonable steps to prevent compliance breaches. And if where there's a failing on their part, that has very serious ramifications. So, I mean, it's not a trivial issue. I assure you, especially for the multinationals.
Thank you very much. Thank you very much to all our speakers for your brilliant answers. We have loads of questions in the Q&A box, but unfortunately, because of time, we won't be able to answer them now. But I promise we will send these questions, we'll collate them to our speakers, they will answer them, and we will put them up on our website. And you can please go onto our website and look at them, www.nba-sbl.org. Click on the Corporate and Regulatory Council Committee web section, and we will have these questions answered for you somewhere there. There was also another question asking if we could share the video or the recordings of this. I'll get in touch with the admin section and confirm if that will be done. And if that will be done, you can also find it in on our website. So at this time, it's my duty to once again thank all our speakers for being very, very erudite. I've learned a lot. It was quite insightful and I've been educated. In interest of time, I will not go through all the pinpoints of what you said. I think our audience, our captive audience, understood them clearly. I'd like to once again thank all those who have put in a lot of hard work behind the scenes in the admin office at the SBL. Thank you very much. Endurance, Rex, Ayomikun, fantastic job. I want to call our attention that this is the second in the series. of the new council of the SBL. The third session will hold in exactly 1 week from today, next week, Thursday, the 17th of November from 3 to 4 p.m. It's going to be a session titled Reshaping Cybersecurity Governance in Nigeria. And they're going to be looking at the amendments of the Cybercrime Act of 2015. That webinar is going to be organized by the Information Communications and Technology Committee. So it's another date next week, Thursday, between 3 and 4 o'clock. Thank you all very much, attentive audience. Without you, we couldn't have done this. Thank you for joining us. Thank you. Have a good afternoon, everyone. Thank you and bye-bye.
Bye-bye. Thank you.
Thank you.
Hey, thank you very
Thanks
much.
all.
Thank you. Bye-bye.
Thank
Bye,
you.
Bye.
everyone.
Thank you,
Bye.
Lilia. Thank you, Luchi. Thank you, Titi. Thank you.